Hey, good morning, everybody. It's Wednesday. Luttrell calls it Happy Wiener Wednesday. I don't want to say anything overtly sexist, especially on the morning after Nikki Nimrata, none of the above. Haley got, I don't know, witch slapped in Nevada. I mean, think about that. You're Nikki Haley. You're the great alternative to Donald Trump. You're spending millions.
Are you, though? Are you great?
Well, in her mind, all she's got to do is be the last candidate standing and hope that something happens to the Donald, and there she'll be, the savior of the republic. So she appears without Donald on the Nevada state-sponsored primary, and Donald doesn't even register in that primary, doesn't apply to be on the ballot. So voters turn out yesterday in Nevada. They have choices: Nikki, several other candidates, and none of the above. None of the above won. There's a suicide watch going on for Nikki Haley right now, but I don't think she's wise.
I feel vindicated for even bringing that up, that was a possible option. It's funny.
I think, a great call. I mean, Mike, as always, it's pretty amazing. So, no love lost there for Nimrata. Let's see what happens.
I feel like saying thank you to Julian. He's not even complimenting my writing. He's complimenting yours.
Yeah, well, thank you, Julian. Yes.
So Julian is the B word, man. Good God, Julian.
Julian is referring obviously
huge already. You know what
Julian
I mean?
is referring obviously to our newsletter. Thank you for reading it, Julian. Spread the good word. Get people out there. I came up in the law writing legal essays. I wrote columns weekly for a legal newspaper for 15, 20 years, and then for a daily newspaper. Kind of burned out and didn't do anything for a while, and now getting back to it at Mike's urging. I had fun in the appellate court yesterday. I just want to talk briefly about this. I mentioned yesterday I was on my way to argue an issue. The issue involved the legal standard for whether an expert should be permitted to testify about the meaning of certain words in a case involving a potential hate offense, racial bigotry. And so the expert was permitted to testify that the mere use of the term all lives matter is racist. The mere use of the mere asking the question of black on black crime is racist. So I challenged that under the Counterman versus Colorado line of cases that said that speech to be inculpatory in any context has to have some subjective component. The speaker has to be aware of what they're saying, and so we had an interesting argument, interesting discussion, the judges and I. My adversary stands up, and he had 20 minutes to speak. He spent the first 7.5 minutes doing something I'd never seen in an appellate court before. He stands up, gives a tribute to Bob Marley, and then quotes Bob Marley, the reggae singer, who was then quoting Haile Selassie, the former emperor of Ethiopia, and then goes into a long recitation about James Baldwin, Frederick Douglass, this, that, and the other thing. And we're all looking at each other like, does he know this is an appellate court, not a high school oratorical contest? So he goes on, he argues. I stand up and rebuttal, and I turn to him and I turn to the court. But I say, I'd like to thank my learned adversary for whatever that was. It certainly wasn't legal argument, and you could hear a sort of gasp in the room. So stay tuned. We'll see what happens. Big news in D.C. yesterday. Trump can be prosecuted for things that he did while in office. I'm looking at a copy of the decision, United States of America, Appellee versus Donald Trump. This is on appeal from a ruling of Judge Chutkan, wherein Trump tried to dismiss Jack Smith's criminal charges against him on the grounds that he enjoyed presidential immunity. As the court noted, the question of whether a former president enjoys absolute immunity from federal criminal liability is one of first impression. In other words, no court had ever considered the issue. The court rejected Trump's claim. He'd made several. One was under the separation of powers doctrine. And I want to dwell on this a little bit and nerd out just a touch on these basic legal concepts, because that's why we're here. Under the separation of powers doctrine, we have three coordinate and equal branches of government. We have the legislative branch, which organizes itself. It's a bicameral house, meaning two chambers. It has its own rules and its institutions. When it acts independently of the other branches of government. The federal judicial branch is organized by both Constitution and acts of Congress. The Constitution creates the United States Supreme Court. Acts of Congress create such inferior courts as exist. Judges have lifetime appointments. But in one of the things that's fun about reading the D.C. Court of Appeals opinion is it impressed upon me that the president of the United States is just one person, but in that one personage is an entire branch of government. Now, there's an executive branch and employees of the presidents, but the president himself is that third branch of government. He is separate and equal to the courts. He is separate and equal to Congress. The Donald tried to argue and did argue in the appellate courts that enjoying that meant that he couldn't be prosecuted under acts of Congress, which is the federal penal code, because he's separate and independent. His cases couldn't be brought against him in a court because that's a separate and independent branch of government. The D.C. Circuit Court of Appeals rejected that reasoning and basically said that presidents rule under law and are created under law. And relying on the old trope that no one is above the law, they argued that Trump is subject to the law as a citizen of the United States and occupying an office created by the laws of the United States. And then it tap danced around a distinction in the law that candidly I still struggle with understanding and seeing how it gets applied in an intellectually coherent manner. And I'm talking about the distinction between ministerial and discretionary acts. A ministerial act is something that is done by rote, a checklist sort of responsibility. A discretionary act is an act wherein a person makes a choice. They use their judgment. The court said what the president acts in his discretionary capacity, where he's making judgments, his conduct should be evaluated under the political question doctrine, which means that the courts don't have jurisdiction over him and he's free to act. A ministerial act, however, does subject him to the rote analysis of whether a law is or is not lawful. So having laid that foundation, the court then did an abrupt turn and said, although he's immune for his discretionary acts, he can be prosecuted. Help me understand that, justices. If in fact he is immune and his acts should be evaluated under the political question doctrine when he behaves using his judgment, and he uses his judgment and in the eyes of someone commits a crime, what makes him not immune? And so the logic is not airtight there. And I think this case is going to go up to the Supreme Court. And I think the Supreme Court will hold. Well, I don't know what they'll hold, candidly. The question presented is a fundamental one. Certainly no one is above the law, but we don't want one branch of government screwed with by another. And we don't want its independence undermined. And so I think the Supreme Court's going to have to take a second look at that question. And when it does, I hope it sheds some meaningful light on the political question doctrine. Those of you
another question for you, Norm, and I'm sorry to take you off track here a little bit, but the decision by the appeals court, it was a 3-judge panel, and they wrote a per curiam opinion. Can you talk about what that means for our audience and the drawbacks to per curiam opinions, particularly in matters like this, where we only see one opinion? And I don't mean to answer the question that I'm asking while I'm asking you, but we have 3 justices or 3 judges giving an opinion as one, but perhaps have varying views, right? We're forced to just look at it in one way. So can you just talk about what a per curiam opinion is in contrast to other types, and whether there's any sort of drawback to us having visibility to what judges actually think individually?
Well, I don't necessarily see it as problematic. I think when a court acts in a controversial manner, it is mindful of the fact that it's behaving in a controversial manner. It's issuing a decision with which many people may disagree, and so you hear accounts of chief justices trying to assure in a difficult case a unanimous decision. Earl Warren, for example, in the 1954 decision of Brown versus Board of Education, declaring that school desegregation violated the Equal Protection Clause of the 14th Amendment, he wanted and got a 9-0 opinion. A per curiam decision is a unanimous opinion. It's by the court. and the three individual judges, in this case in the district court, who were on the panel, agreed with the decision, and therefore it was Judge Henderson, Judge Childs, and Judge Pan. What the per curiam means is this is the decision of the court. We don't know what the three individuals themselves, if they had nuanced disagreements or not. I actually think that enhances the credibility of the decision. Typically, however, you see a decision, it might be 2-1. With people disagreeing, of the two in the majority disagreeing about what the result should be, reaching it by different conclusions, that creates some confusion in the law. Then you've got a dissent that gives hope to the other side, that maybe there's another court on another day in another way who might see it differently. So I view the per curiam decision here as a signal from the court that it was speaking with one voice rather, and it was speaking decisively, and it meant to send a powerful message. We feel so strongly about this. There are no nuances about which we disagree. There is no hope. There is no wiggle room on appeal. Now, the Donald has two choices. He can ask for a hearing en banc. In other words, he can ask for all of the judges of the D.C. Circuit rather than these three to hear it. A per curiam decision sort of says, save your breath. We're speaking for the court, and there's not a lot of wiggle room here. By way of a separate order, independent of the decision, the D.C. Circuit did not issue a mandate. In other words, the D.C. Circuit maintains jurisdiction over this case right now, and Judge Chutkan is not free to place it back on the trial docket. But they're going to withhold the mandate until, I think, Monday, February 12th, unless and until Donald Trump files an emergency application in the Supreme Court to continue the mandate while he prepares a petition for certiorari.
Well,
And so
hold it to pay some more money.
yeah, I predict by Monday there will be filings in the United States Supreme Court, and the United States Supreme Court will decide this. One other just legal nerd note, Mike, because it's a fascinating argument, and I don't know, if I don't know if you find this as compelling as I do, but one of the arguments Trump tried to make is that in the impeachment and judgment clause, he was barred from prosecution on something that looks like double jeopardy grounds. That clause, and I never really read it carefully until last night. I'll be honest with you. It basically says that the only punishment for impeachment can be disqualification from office, removal from office, and disqualification from service in the future. Nevertheless, the Constitution reads, when a person has been impeached, they may subsequently be prosecuted. So Trump tried to argue that because he was never impeached, he wasn't convicted, that barred the prosecution. The court made short work of that and slapped him around.
Well, so what they said is this. It's kind of interesting, right? They said that in part, quote, as a result of the political nature of impeachment proceedings, impeachment acquittals are often unrelated to factual innocence.
I think that's true.
But it's an amazing admission by the court, considering how hard establishment media went for each of the three impeachment proceedings against Trump during his presidency.
Well, the establishment media has lost so much credibility.
Understood, but it's just interesting that that is in writing in this case, and that is from the same opinion, saying that he can be tried as a citizen, or just rejecting his claims of presidential immunity. Him bringing up, hey, I was acquitted of impeachment proceedings related to this, and the court just says, those are too political.
Well, maybe. What? Well, so off we go. Off the Donald goes. I'm marveling this morning at the state of the world, because what we've got is, none of the above, Nikki, getting slapped around in Nevada. There'll be Republican caucuses later in the week where Trump will presumably get the vote, and then so Trump is emerging as the Republican candidate. There's no question about that. Well, the courts very much are holding in question his ability as a matter of law and as a matter of fact to serve as president. I don't know what the year is going to bring. I mean, if we get to be 3-4 months from now, and the Supreme Court has said he's supposed to be, he can be kept off the ballot, they greenlight the prosecution, Jack Smith gets him convicted and locked up, and he gets 50, or he wins the Electoral College. What becomes of the country then? I mean, talk about a walking anxiety attack. It's enough. It's enough to make me want to get out of bed in the morning and start reading the newspaper and talking to you folks. What a year it is, and what a year it is for Tucker Carlson.
I
There
think
were
I sent
rumors
you this.
earlier in the week that he was spotted in Moscow, and now what's this, Mike?
Yeah, I think I sent you this video yesterday, and you had a one-word response. Wow,
Yeah,
right? And so Tucker did. He posted it. He published a video on X, and what I'm going to show here is a very famous celebrity rapper Meek Mill. He's got 11.3 million followers on X, and this is another one of those motifs that I keep attempting to just kind of shove into the conversation, which is the populist political right is the domain of rap now, right? If the conservative populist right movement will have it, it can embrace a new demographic shift in voting patterns. This is a testament to that. Meek Mill is a very famous Philadelphia-based rapper. He is at the peak of that. He's been in major controversies with other A-list celebrity rappers and BS like that, but it speaks for the streets, whatever. Anyway, culturally hyper relevant. Look at this quote post of Tucker's video. It says literally, "Let me see what's going on before we get caught in a war we don't have nothing to do with." Ellipses. So what Tucker posted is a preview, right? He explains why he's there and what he attempted to speak about. And I can play
We're here to interview the president
things
of
here.
Russia, Vladimir Putin. We'll be doing that soon. There are risks to conducting an interview like this, obviously. So we thought about it carefully over many months. Here's why we're doing it.
lawyered up.
First, because it's our job. We're in journalism. Our duty is to inform people. 2 years into a war that's reshaping the entire world, most Americans are not informed. They have no real idea what's happening in this region, here in Russia or 600 miles away in Ukraine. But they should know. They're paying for much of it in ways they might not fully yet perceive. The war in Ukraine is a human disaster. It's left hundreds of thousands of people dead, an entire generation of young Ukrainians, and it's depopulated the largest country in Europe. But the long-term effects are even more profound. This war has utterly reshaped the global military and trade alliances, and the sanctions that followed have as well. And in total, they have upended the world economy.
Wow.
Yeah, no, I can't help but wonder whether federal prosecutors are going to be looking at Tucker. I mean, we're funding somebody that's at war with Putin and Russia. Is he going to be deemed to have offered aid and assistance to an enemy of the United States just by sitting down and talking with this guy? Will there be efforts to block publication of the interview? I don't even know how to think about that question, Mike.
Well, he also he in this same video, he admits that he has spoken directly with Elon Musk, and Elon Musk has promised not to censor or hamper anything related to distribution of the don't get us distracted here. Anything related to the distribution of the interview. I also understand you're getting us distracted again.
Maury, I'm trying, Maury.
I am interested to understand this, but it's taken away from the point. So he does say in the interview that Elon Musk is going to support distribution of this. It won't be hampered. It won't be limited. It won't be censored on the platform. And I thought, interestingly enough, the New York Times headline here says a lot about this, right? Because Tucker brought this news to people in America. He brought this news directly to his timeline. And what does the headline actually read from the New York Times? Tucker Carlson has interviewed Putin, Kremlin says, which is an interesting way to shift away from acknowledging anything that Tucker Carlson is doing as a journalistic media figure, right?
Yeah.
So this is foreshadowing, in my opinion. This headline in and of itself is foreshadowing as to how this is going to be treated. My question for Tucker is ultimately, is this a statement of your belief in the American people to withstand exactly what may happen as a consequence of you going to Russia right now and interviewing Vladimir Putin? Because this is a huge statement. It's a huge move. I don't attribute any sort of malice, a forethought to Tucker. I don't really attribute to him some sort of unbridled ego or narcissism. But I
You
am
don't?
but I am a pragmatist. And I
Yeah.
do think that ordinary people are going to be negatively impacted by the response of the establishment media, the establishment governing bodies, right? The DOJ, et cetera. January 6 prisoners, even more, right? We have an immigration bill that's going to die, but it allocates an additional $60 billion for the war in Ukraine. I'm seeing videos come across my timeline now how Ukraine is actually drafting women into the military and pushing them into the war zone, young Ukrainian women, right? We are in a very strange place. And what he said there is that most people are not informed. The overwhelming majority of people are not informed. I am interested to understand what exactly Putin is going to have to say on the topic of what their interest is in this war. I am.
Yeah, I would like to hear from him as well. And that is an interview I will likely watch. I I'm of an age where I remember the Soviet Union and Soviet communism and the contest between East and West and the fall of the dissolution rather of the Soviet Union and the triumphalism in the West. But yet Russian nationalism remains a very potent force, and it is opposed to the westernizing influences of Western Europe. And so Putin, I think, represents an iteration of a form of populism that is an ideological cousin to the populism in Hungary, the populism in Argentina, the populism in Brazil, and the populism in the United States. And I view Tucker as tap dancing on some very dangerous coals here.
Thousand. Jackson
Putin
Barrett
is.
asked a question as well, which I think is a really interesting one, and maybe it's not as interesting to you, Norm, but he says, did Tucker speak with Assange, Snowden? And
Well, one would hope, that would be more interesting to me than him speaking with Putin, because Putin does have an anti-Western agenda, and it is a different geopolitical orientation than what is than the United States' orientation to the
what
world.
is the Western agenda, though? I think
I don't know that we have one anymore.
right.
And that's the
So I
problem.
think this is why this is an attractive conversation for the average person that is not close to or in close proximity to the levers of power, that does not have family or contacts within the establishment of DC, the DMV area in Southern California, Manhattan. These are this is a conversation that is, I think, the brightest among all of them, and it's something that I think Vivek Ramaswamy did a brilliant job of bringing to the surface, right?
Maybe. I think the deeper end game is that Putin senses weakness, that the Western agenda, the Western ideological
Why
superstructure
wouldn't
has
he?
collapsed, and
Why
there's
wouldn't
there's a vacuum, and he wants to appeal to the West with his anti-Western rhetoric.
I
And
saw
I'm
an
just not
interview
so
where
sure
he
about.
was. I saw an interview from a couple of years ago where he was criticizing the U.S. government for charging 450 at the time, charging 450 January 6 protesters for speech for criminalizing their speech, saying that
Yeah, but that's just pandering. They would have been
of
lined
course,
up and
of course,
shot in Russia.
of course,
So,
but he
oh,
obviously
look at what you're doing to your own people. Never mind the
exactly.
fact that
And
I
look,
do worse
he
to my
obviously
own. I
all
mean, I
I'm
don't want to be pandered to.
but my only point is that he most certainly perceives weakness. And is he
Well,
wrong?
he does, and so is Tucker. Who's Tucker serving here? I was surprised when you said you don't view him as narcissistic and self-involved. I mean, it's I don't know what Maury means when he calls or when Maury calls Tucker, the male Taylor Swift. I'd be interested in hearing a little more of that. I'm a little suspicious of Tucker's motives. I mean, it's one thing to say that pluralism has run its course, the bottom has fallen out of pluralism, we've become decadent and distracted. It's another thing to say, let's adopt a pan-Slavic attitude. I don't think we're going there either. So this is a really interesting topic. It's kind of
That's
sort of
fascinating.
outside my bandwidth. I can't wait to see the interview. Do we have any idea when it's going to be published?
So my understanding is that he's not going to sit on it very long. If history teaches us anything, he's probably, he admitted that he attempted to do this interview a couple of years ago or a year or so ago, but the Biden administration spied on his communications with his team through text message, emails, etc., and ran a blockade and sort of spoiled that. And they did the same thing this time, but he says he went anyway.
Well, it'll be interesting to see whether they try to gin up some criminal prosecution of Tucker. That would present a profound challenge to First Amendment rights because I do want to hear what Putin has to say, but I'm suspicious of both Putin and Tucker's motives. So we had a conviction yesterday in the Crumbly case. Ethan Crumbly's mother was convicted of involuntary manslaughter in Michigan. Crumbly, you will recall, was a troubled young man who appeared in a school. He had drawings of himself engaged in a shooting and notations begging for help. School officials saw that, called Ethan's parents in, and Ethan's parents left him in school. And that afternoon, he shot and killed classmates. The state of Michigan brought an more or less unprecedented prosecution against Crumbly's parents. The two parents are being tried separately. The mother was tried and convicted of 4 counts of manslaughter. Just yesterday, Ethan's father will be prosecuted, or tried, I should say, next week. Manslaughter in Michigan carries a maximum of 15 years per count. Michigan officials have said they will seek consecutive sentences or a sentence of 60 years for her. What is involuntary manslaughter? So in the criminal law,
Before you ask, may I ask another
Yeah.
question?
yeah,
This is somewhat rhetorical, but I'm still gonna. Why wasn't the dad charged?
he is.
Was
He's
he
being charged next month. He's
okay?
being tried next month.
Okay.
The cases are severed. So apparently the father brought, I can't remember if he bought a 9mm, I think it is, for the son, a troubled kid, and the mom took him to target practice. They weren't tried together because typically co-defendants are not tried together. There may be lesser and greater degrees of culpability as between the two, and you can't call your co-defendant to testify as exculpatory evidence in your case because of Fifth Amendment issues. No person can be compelled to testify against themselves. So under the case of United States versus Bruton, Bruton, whenever there are co-defendants tried with differing degrees of culpability, there's usually a non-waivable conflict and they get tried separately in separate proceedings. So Mom Crumbly was tried first, and she was found guilty of involuntary manslaughter. Involuntary manslaughter means that you either recklessly or negligently placed someone in a position to cause the death of another. Not that you yourself intended to cause the death of another, but that you placed someone in a position where they could do so, and you either were reckless about it, meaning you were aware of a substantial risk of harm and were either didn't care or were extremely indifferent to human life and proceeded nonetheless to let that reckless event unfold, or you were criminally negligent. In other words, your conduct amounted to a gross departure from the standard of care that we expect of people in your circumstance. So the bottom line here is that
And such negligence was a proximate cause of the
right,
eventual act.
and that's an important thing. Thank you for adding that, Mike, because that's what makes this case significant. The case is significant for 2 reasons. First, it's the first time parents have been held criminally liable for the acts of their children in a mass shooting, and so the victims of her son's shooting in Michigan praise this as a victory for accountability. But the danger isn't in this is it strains and stretches the notion of proximate cause to its breaking point. Was it? And it may be that this case is just such bad facts that it's not precedent setting, because after all, this young man's parents were summoned to the school um, in response to seeing drawings of him shooting, and in response to hearing him cry for help and saying that he couldn't control himself and so forth, and they left him in school and he killed kids that very day. I mean, that's just such a horrible fact pattern. It's unlikely to recur. The legal principle that it stands for, however, is that a parent is legally responsible for the acts of their children when those children engage in criminal conduct. Now, I'm not comfortable with that. While this is sort of like the revenge of the anti-gun lobby for the Second Amendment's individual right to bear arms. Basically, what it's saying is, okay, you have a right to bear arms, but we're going to hold you responsible for whatever happens with those arms, regardless of whether you were involved in the shooting or not. So, I expect an appeal in Miss Crumbly's case. I don't know what the Michigan appellate courts will do. I don't know enough about Michigan law or the Michigan statute. But this case will go down in history as a turning point in American jurisprudence, because what we now have is a form of vicarious liability. That is, a liability for the acts of a third party imputed onto parents when their children engage in independent criminal conduct. A 15-year-old shooting another can be charged as an adult, even though they're a juvenile. And proximate cause usually means that does mean that you're legally responsible for the harm. In this case, a mother has been found criminally liable for causing harm her son caused to others, because she either didn't take the gun from him, she didn't take him home from school, she didn't get him the mental health care he needed, and therefore she's now a criminal. I'm uncomfortable with that.
Yeah, so my initial reaction here, and first of all, Rumble is going bananas right now on this topic, so we should revisit this, Norm, and stay involved. I know that we reported on this, we discussed this many months ago when it was first coming down, um, but our chat on Rumble is very opinionated about this. We have, it seems like, a pretty even split of those who are against it, those who are unequivocally for it, and those who are on the fence. Among those who are overtly for it, Critical Thought, good morning to you. Always nice to see you in here. Um, she is 1000% on board with this, right? That even if the kid stole the gun, she says he's a school shooter. Parents are shitty and or totally blind. Zero sympathy. T-Girl offers agree critical. However, sometimes parents are prohibited from getting help for their kids. Courts are removing parental rights at an alarming rate. And then, it's me again, says school should have put the kid on a 48-hour mental hold and had him sent to the hospital, et cetera, et cetera, et cetera. My thing is this. I think that parents everywhere should embrace this conviction, because I think parents need to know their children. I struggle because I have a young son, and God willing, another on the way. And
Wait, God willing, what are you
yeah,
claiming? Or what are you trying to tell us?
yeah, number 2 is due later this year.
Yeah, Mike. All right, you go, boy. Yeah.
And I have, I don't want to apply or project judgment onto this woman because I don't know her, but it is tough for me to create I guess a mental model that would, where two of these things are true at the same time, that the parents enjoyed a close and loving relationship with their child, and that he was also still capable of getting away with as much of the things he was getting away with. That the father, in gifting the Sig Sauer 9mm to his son for his birthday, was somehow totally conscious of all of the other red flags that existed prior to the shooting. I would, and I think I personally think that accountability for this does start in a home, and I also am starting to think that perhaps this is the way to mitigate gun violence in schools. This may be a platform, a policy platform that could bring left and right together, right? If the left will stop trying so aggressively to do away with the Second Amendment, and the right can acknowledge that there is additional accountability to be had for parents of school shooters, there is something here to say, look, we are a community, we're responsible for these things. Parents, you must be involved with your children. And in heinous acts of violence such as this, we must look deeper into the environment that allowed for this sort of thing to happen. Now, again,
But I worry about the slippery slope argument. There was a famous case in Connecticut, so famous I can't recall its name, years ago. Young boy killed himself, and the state of Connecticut brought a risk of injury to a minor charge against the mother. He was being raised in a single parent home. And among the things it concluded was, she was such a the house was a hovel. She was a hoarder. It was dirty. It was unkempt. It was everything. And the claim was that she was such a bad mother that this was a material factor in the kid's killing himself. And under the Connecticut risk of injury statute, a person is guilty of risk of injury if they engage in conduct that it undermines the health, education, welfare, or morals of a child. And so his killing himself obviously was proof that something was amiss. And her style of parenting and housekeeping and whatnot was circumstantial evidence that she was a bad mom. The appellate court reversed that as sort of vague, a vague application of the statute. And I applauded that ruling at the time. This was 10, 12 years ago. In this case, I think we're back to the states becoming a superintendent of what goes on in the home and holding parents criminally liable for failures in it. Now, it just may be that these are bad enough facts that it doesn't set a precedent. But and I hear what you're saying, Mike, about community standards and looking for a way to bridge the gap between left and right. You may be right. I think we need to revisit this one.
Yeah, and again, I mean, this is the gifting of a firearm to a
Well, there
child.
is that.
You know what I mean?
Hey, happy birthday, son. Here's a Sig Sauer 9mm. How's school going? I want to kill everybody. Mom. Oh, you don't really mean that. Let's do some target practice. Yeah,
Right.
I hear you.
There is, and again, this isn't just happen in isolation. Obviously, there are facts sufficient for their prosecution here to be warranted. Norm, you are much closer to the procedure of this than I am, and you understand how these things function in a criminal court. But from where I'm sitting, you know, I think that it was initially my reaction months ago was, man, this is not a great situation. That parents are now being blamed for the acts of their kids, taking away agency. But I do think that children under the age of majority are still kids, and they lack consent. They lack the competence and the ability to even to consent to contracts, right? And for
Yeah,
that,
but you know,
you know,
this is where the law is hypocritical. They lack the capacity to enter into contracts, but we can charge them as criminals if we don't like what they did. So do they have agency or do they not? And and I think it's a sort of arbitrary line that we impose depending on the interests we seek to vindicate.
I'm interested to see if
This
there's any legislation in Michigan that comes from this and other places in the country. I think that the conviction here may not stand like you're saying, Norm, but I do think it will inspire legislative sessions to figure that out.
Let's pivot real quick. You're talking about a bridge issue between left and right, right? And I had a very interesting experience last night. I was invited to be the dinner guest and speaker at a fraternal society at Yale. Half of the people who turned up at the event, much to my surprise, about 28 people turned up, and we sat around a long table and spent the evening talking about what it's like to be a lawyer. And I tried to be honest with them. Afterwards, I had private conversations with many of the people in the room, and there was a real hunger from among the law students for discussions that could bridge the gap between left and right. And so several of them said, if we could arrange it, would you come and speak at the Yale Law School? And I'm like, I'm not sure I want to get involved in that rat's nest, and they're like, and there was a real sense of imploring me to reconsider, because I think, as you point out, Mike, people, we live in communities together, and there is a hunger for standards that can draw us together. And so in the same way that you are suggesting that the Crumbley case might invite discussions of a middle ground between right and left, what I saw from these young Yale law students was a hunger to have those discussions in their law school, and they were having to look outside the law school to bring speakers in who might foster those discussions. I'll keep you posted on whether anything comes of that.
That's awesome, and I know that you had planned for that a couple months in advance. So I hope you do end up going to the law school and speaking, and maybe we can turn that into something.
Yeah, maybe. So listen, folks, we've talked our way through another whatever day today. Oh, that's right. It's Wednesday. That means tomorrow is Thursday. And tomorrow, obviously, the case of United States of America versus Donald Trump will be argued in the U.S. Supreme Court. I'll be in the Connecticut appellate court arguing Alex Jones's damages case to the appellate court. Obviously, the Trump case will capture the headlines, and for that, I am relieved. I'm tired of being in the news on the Alex Jones case. So thank you for listening in. Where do people find us, Mike?
Well, most of you all are finding us on Rumble today. I'm just really giddy over how lively the chat is. Thank you, everyone. Lawyer Will, it's me again. Bathtub Liquor, Critical Thought. Man, I'm Hans.
Oh, Lawyer Will. I know you and Pete, your brother Pete Atkinson, keep
In the
track.
cloud.
Pete Atkinson's coming out to dinner in New Haven Friday night. He and I will be eating at a local restaurant Friday at 6. Where will you be, Will? Maybe we'll talk about you. Maybe we won't.
Well, and you can also find us on YouTube. Thank you for everybody over on YouTube. Other Angry Dog. Hey, it's been a while since you've been active, so glad to see you back here. Mari, you got jokes, and they're pretty funny, admittedly. But thank you for being here. Barry Thompson, nice to see you. Jackson Barrett, you're on X, you're on YouTube, and you're on Rumble. You're a prolific man. Assuming that Jackson is a male name. Anyway,
and Jackson is a natural born citizen. We know. Hi,
absolutely.
Jackson.
So follow us over there. YouTube, on X at LawPod Daily, Rumble, Law and Legitimacy.
And I want you to check out our newsletter because, as Julian Toll from Down Under puts it, my essay style is pretty cool. It's punchy, it's legal gonzo, and it's not too dumb. So thank you for the kind words, Julian Toll. We'll see you all tomorrow.
That's right. And I'll throw it on the screen here one more time. This is the newsletter, issue number 4. And Norm has 2 really, really striking pieces this week. Please go and read it. Subscribe if you have not. I got a couple of emails from you yesterday. One of you asked if I can send previous issues because you're a new subscriber. The answer is absolutely, although I do beg for your patience because Norm and I both have other things that we are vacuumed into once we get off the stream in the mornings. So please give me a little bit of time, but I will answer every single email and I will get you the past issues as well. All that I ask is that you all please continue supporting us, leave a thumbs up on the video, and recommend us to someone that you respect. Norm, I will see you tomorrow, my man.
You will be well. Stay safe and congratulations. Mike's pregnant. I'm
going to be sick.